Let's be realistic about what the goals of asset protection planning are. Not to win every motion, although it's nice if that happens. Not to cause the adversary to run off with its tail between its legs, although it's nice when that happens. Realistically, to weather a claim at least moderately better compared to what the result would have been had there been no planning. So we look at what the result would have been had there been no planning in place. We look at where we ended up when everything was said and done with the planning in place, and we determine whether or not there was a victory. Now, there's a very recent case out of Alaska by the name of Mortensen that we're going to look at later today, tomorrow. The court says something like, in not recognizing the transfer to the trust, this fellow is going to pay the ultimate price, and the ultimate price is, and you gasp, you think, oh my God, what is that? Is he going to be beheaded, or what are they going to do to him? And they say, he's going to pay the ultimate price, and the transfer will be unwound. Well, and he's kind of restored to his original position. Now, aside from the fact that there's a lot of issues with that Mortensen case, the facts, and indeed the decision itself, the point is, in a sense, he was no worse off than he was had he not tried to do what he was going to do. And we're not talking about fraudulent transfers. We're assuming that away in what we're talking about in our planning. The point I'm making to you is that in good cases, where you have the hopes and expectations, realistic expectations of good results, I mean, even if a $5 million settlement is paid, for example, if the other result would have been the client losing $15 million out of the estate and then taxable gain of another $8 million, a $5 million settlement is pretty good. So again, it's a comparison of where you would have been, and that's the proper perspective.